Video notice to the United States Congress for creating invalid and unlawful contracts with private corporations. The people created government. We, the people of the 50 American states, as seen in the Bills and Declaration of Rights in the 50 state constitutions, sui juris, am serving you with this notice so that you and your agents may provide due care. The term sui juris is a special term and it means of our own right. And provide due care. Due care is a special term and it means to provide just, proper, and sufficient care with the absence of negligence. So those are special terms in there. Please take notice that we the people are the creators of all government in our nation, both state and federal. See evidence below. Virginia Constitution, Article 1, Section 2, People the source of power. That all power is vested in and consequently derived from the people, that magistrates are their trustees and servants, and at all times amenable to them. Magistrate means a public civil officer, and amenable means liable to answer, responsible to. Our rights are reserved, and reserved means to hold back, to keep, to retain. Please take notice that we the people reserved all rights declared in our Bills and Declaration of Rights in our 50 state constitutions, and no government has been granted any power or authority to create any legislation over these rights. See evidence below. Texas Constitution, Article 1, Section 29, Provisions of Bill of Rights accepted from powers of government to forever remain invalid. To guard against transgressions of the high powers herein delegated, we declare that everything in this Bill of Rights is accepted out of the general powers of government and shall forever remain invalid, and all laws contrary thereto or to the following provisions shall be void. Accepted means to take or leave out, and inviolate means unhurt, uninjured, unbroken. And notice it said herein delegated. These powers were delegated from us, we the people. Government only exists because they received power and authority delegated to them from we the people. Maxim of Law 11F. Power can never be delegated, which the authority said to delegate never possessed itself. The right to sue. Please take notice that we the people are aware that only the legislators are vested with the authority to create laws and charters to establish corporations in our country. As set forth in the Arizona Constitution, all corporations shall have the right to sue and shall be subject to be sued in all courts in like cases as natural persons. Who granted the United States Congress the power to disregard the authority of the people and the laws they established in the state constitutions? See evidence below. Arizona Constitution, Article 14, Section 1, Corporation, defined, right to sue and suability. The term corporation, as used in this article, shall be construed to include all associations and joint stock companies having any powers or privileges of corporations not possessed by individuals or co-partnerships, and all corporations shall have the right to sue and shall be subject to be sued in all courts in like cases as natural persons. A charter is an act of legislation creating a corporation. The federal Congress has to accept all the state constitutions because they were all ratified. No law granting immunity. Please take notice that no law granting any privilege, franchise, or immunity shall be passed by the legislature. When did we, the people, delegate to the United States Congress any special privileges that allowed them to create special laws granting immunity to vaccine manufacturers? See evidence below. Washington Constitution, Article 1, Section 8, Irrevocable privilege, franchise, or immunity prohibited. No law granting irrevocably any privilege, franchise, or immunity shall be passed by the legislature. Bound by trust indenture. Please take notice that the 51 constitutions are the trust indentures to which all trustees and servants are strictly bound. No government has been vested with the authority to create any bill of attainder, ex post facto law, or law impairing the obligation of contracts, which includes your contract with the people. So a trust is a right of property. It could be real or personal property that's held by one party for the benefit of another. A trust indenture is the document which contains the terms and conditions which govern the conduct of the trustee and the rights of the beneficiaries. A bill of attainder is the legislative acts that apply to named individuals or members of a group that inflicts punishment on them without a judicial trial. California Constitution, Article 1, Section 9 says, a bill of attainder, ex post facto law, or law impairing the obligation of contracts may not be passed. Ex post facto law means a law passed after the occurrence of a fact or commission of an act which changes the consequences. Title 42. Please take notice that Title 42, the Public Health and Welfare Act, is a non-positive law title not yet codified by Congress and is simply an editorial compilation of statutes. Therefore, the entire application of Title 42 is created under the presumption that something which is a total fiction of law is true. If you believe Title 42 has been enacted by the United States Congress and is a positive law, please provide the provisions showing where it was lawfully codified by Congress. So the Public Health and Welfare Act is a non-positive law, which means it was not enacted by Congress. Maxim of Law 45B. A fiction is a rule of law that assumes something which is or may be false as true. Maxim of law is a principle of law universally admitted as being a correct statement of law. Undue influence. Please take notice that Title 42 has been used by the government to harm the people. Are you aware that Title 42 has created undue influence on the state governments, forcing them into allowing unconstitutional actions to be taken against the people? See evidence below. Maxim of Law 60I. A hidden intention is bad and disfavored in law. Maxim of Law 60L. Intentions ought to be subservient to or in accordance with the laws, not the laws to intentions. 42 U.S. Code Unlawful. Please take notice that 42 U.S. Code 300AA-22, the Standards of Responsibility, is an unlawful, unconstitutional act and is void, as no legislature, including the United States Congress, has the authority to pass such law impairing the obligation of contracts, nor granting any immunity to any corporation, including granting immunity to vaccine manufacturers, companies, and its agents. So this is the actual 42 U.S. Code standards that they want us to believe was enacted by Congress, but in reality it was not. So A, general rule. Except as provided in subsections B, C, and E, state law shall apply to a civil action brought for damages for a vaccine-related injury or death. B, unavoidable adverse side effects warnings. No vaccine manufacturer shall be liable in a civil action for damages arising from a vaccine-related injury or death associated with the administration of a vaccine after October 1st, 1988, if the injury or death resulted from side effects that were unavoidable, even though the vaccine was properly prepared, it was accompanied by proper directions and warnings. 2. For purposes of paragraph 1, a vaccine shall be presumed to be accompanied by proper directions and warnings if the vaccine manufacturer shows that it complied in all material respects with all requirements under the Federal Food, Drug, and Cosmetic Act, and Section 262 of this title, including regulations issued under such provisions applicable to the vaccine and related to vaccine-related injury or death for which the civil action was brought, unless the plaintiff shows A, that the manufacturer engaged in the conduct set forth in subparagraph A or B of Section 300AA-23D2 of this title, or B, by clear and convincing evidence that the manufacturer failed to exercise due care, notwithstanding its compliance with such act and section and regulations issued under such provisions. C. Direct warnings. No vaccine manufacturer shall be liable in a civil action for damages arising from a vaccine-related injury or death associated with the administration of a vaccine after October 1, 1988, solely due to the manufacturer's failure to provide direct warnings to the injured party or the injured party's legal representative of the potential dangers resulting from the administration of the vaccine manufactured by the manufacturer. D. Construction. The standards of responsibility prescribed by this section are not to be construed as authorizing a person who brought a civil action for damages against a vaccine manufacturer for a vaccine-related injury or death in which damages were denied or which was dismissed with prejudice to bring a new civil action against such manufacturer for such injury or death. E. Preemptive. No state may establish or enforce a law which prohibits an individual from bringing a civil action against a vaccine manufacturer for damages for a vaccine-related injury or death if such civil action is not barred by this part. No suppression or interference. Please take further notice that any man or woman who decides to suppress this notice agrees to pay $100,000 per infraction, and any disputes by any public officials and or private actors who are bound by contract to the state and federal constitutions agrees to have these matters heard before an arbitrator of our choice. Moreover, no bar association members are authorized to handle or interfere with these matters, and any attempts by any bar association members will be considered a direct trespass on the people's rights. Wish, order, and demand. Please take final notice that it is our wish, order, and demand that all trustees, servants, agents, and bar members are to immediately stop blocking and interfering in the people's inherent rights, including the right of any individual to seek compensation, damages, or retribution for injuries they may have received on their person due to the injection of COVID-19 vaccines or for any other reason. Furthermore, if you believe any of the above claims are untrue, or that you have the authority to grant power to a public-private charter corporation and or delegate your power in any way which would allow any public servant, private actor, or corporation to infringe on the people's rights, please show where you were granted these constitutional authorities. All responses must be submitted by affidavit, sworn under penalty of perjury, within 5 days of receiving this notice, or you agree, by acquiescence, all statements in this notice to be true and fact. Further, you agree that you are acting with full intent, knowledge, and malice by trespassing on the people's rights, and that no court shall be able to rehear this matter, but it shall stand as evidence and truth in all courts of record. Please post publicly on your agency's website to include any other social media or public platform. This notice is sent to you in peace and with the love of Christ, so that you may provide due care to those who have all political power, the people. Due care means just, proper, and sufficient care, so far as the circumstances demanded, the absence of negligence. Final instructions. There is a link in the description box below this video for emailing this notice to selected individuals. You can click on the link, fill in your information, and hit submit, and this notice will be emailed to the individuals listed on the notice. You can also print out a copy of this notice on legal-size paper, single-sided, and mail by certified return receipt to have proof you sent it and evidence that they got it. Keep the original for yourself and mail copies to the names listed on the notice. The only way change will come is if more people will take action. This is an easy way for you to be involved. Submit this notice and forward this video to others. Knowledge is power. Share the knowledge. Thank you.